Good evening, everyone. We, wel- we welcome each one of you to our Advocate on Record Aspirants Academy. Let me move on to the topic for today. And before that, it is our regular practice that we recite preamble. We feel that preamble is our unity and divinity. So therefore, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now let us move on to the topic for today. Very, very important topic, not only for AOR examination, but also for our practice. The topic is how to draft substantial question of law and grounds in SLP civil matters. That is the topic. So how are we going to approach this topic, dear friends? Right? I am going to approach this topic by taking the reference of one of the honorable sitting judge of the Supreme Court, Honorable Justice Suryakanji. My Lord has addressed the new AORs when AOR Association organized for the felicitation of new AORs. It was headed by Honorable Justice Suryakanji. My Lord has said AORs are the lifeline of judicial justice delivery system. Lifeline of justice delivery system. Then I went to find out what is lifeline. Lifeline is when we are struggling in a water, when you are drowning in a water, the rope which is given to us, it is a lifeline which saves our life. When a company is in financial crunch, somebody is going to help financially, that is a survival to the company. When a starving person is about to die because of poverty, if somebody brings food, that is a lifeline to his life. So therefore, dear friends, for justice delivery system, the lifeline is advocate on record. Judges are saying, therefore, see the importance of being an advocate on record. The Supreme Court rule says an advocate on record means who can act and plead on behalf of the party. If you are an advocate, you need the guidance of advocate on record. And senior advocate has to be assisted by this advocate on records. But advocate on record can independently function from the beginning till the end. Therefore, there is a lifeline of justice delivery system. Not only my Lord has said about the justice delivery system, but also advised young people of new AORs how to draft with persuasive value. My Lord has explained in various ways, but I will put it in a nutshell by bringing 5 C's, dear friends. 5C, A, B, C, right? 5 C's. First is how a drafting has to be. First C is curiosity. Draftsman has to create curiosity for the reader, that is the judge. Honorable judge, when they are looking at a special leave petition or a writ petition, the first paragraph must create curiosity for the reader, for the judge, number one. That curiosity, second C is compulsion, compelling the judge to read further. First C is curiosity, second is compulsion. Third is continuity. When there is a flow, the flow should be continuous flow. There should not be any, for example, you take one ground and separate ground, that should not be there. It is like your life from your childhood, adulthood, old age, then handshake with God. It is there are stages. So likewise, the petition should also to be drafted in a very continuous manner. Right? Third is continuity. Fourth C is, dear friends, clarity. There should be a clarity in your petition. And fifth C is coherence. There should be a link, logical and consistency. Therefore, there should not be any self-contradictory statements in your petition. Therefore, these 5 C's are very important, dear friends. One is curiosity, leading to compelling the judge to read. Thereafter, continuity, clarity, coherence. So, these are all the 5 C's are very important for persuasive drafting as per my Lord, Honorable Justice Suryakant. Now, let us taking the guidance, being the guiding light of all these 5 C's, let us take it and let us try to draft the grounds and substantial question of law. So, this SLP comes where it has comes from. It is Article 136 of the Constitution of India. The Supreme Court has the power to grant special leave against any judgment, degree, determination, sentence, order passed by any court or any tribunal in the territory of India. Right? That is the general clause under Article 136 Clause 1. 136 Clause 2 says that when SLP will not lie, when a judgment or order passed by any court or tribunal constituted under the armed forces, SLP will not lie. So this is Article 136. We must read it with Order 21 of Supreme Court rules. What does it say, dear friends? Order 21 deals with special leave petition in civil matters. And more particularly, SLP, what format it is to be followed? Form number 28. Form number 28 appended to Supreme Court rules itself. It has got the format. Let me take you to form number 28. Let me read first question of law, the format alone. Question of law, the following questions of the law arise for consideration by this honorable court. Within bracket they have given, here set out the question of law arising for consideration precisely. Precisely means don't make it very lengthy, make it concise, precise, with clarity. And 5 is grounds. Leave to appeal is sought for on the following grounds. Here specify the grounds precisely and clearly. Now, before approaching this, what is substantial question of law? We must know. We must ask ourselves, what is question of law and what is substantial question of law? Question of law means very simple. Let us dissect the term. Question means what is your name? Where are you coming from? We are putting the questions. You will say, my name is so and so, sir, I am coming from place. What is question of law? For example, we are drafting a specific relief act and we are bringing the facts coupled with the section 6 of the specific relief act, which gives protection for the possession. When a person is in possession of the suit property, he cannot be dispossessed even by the owner. Even by the owner, a person who is in possession cannot be dispossessed forcibly. without following the due procedure of law. So section 6 gives the protection, right? If somebody is dispossessed, for example, tenant is dispossessed, he is not paying the rent. What is the remedy to the landlord? He has to file a eviction petition. He does not file it. He brings 5 people with unlawful assembly and they enter, trespass, and they put all his belongings, tenant's belongings outside. They throw him out forcibly. That is not the law says. So he can go and file section 6 of the Specific Relief Act, a suit for possession. So it protects. So therefore here tenant is removed forcibly, that is the fact, and you are taking the aid of section 6 which protects you. So that is how you will interpret. Then what is interpretation? Whether section 6 applies to this case or not. Question of law. You are questioning that whether section 6 applies to your case or not. That has to be determined by the court before whom you are urging this. So this is what the question of law, dear friends. Secondly, there is a case law, dear friends, where the Honorable Supreme Court has held what is substantial of question of law means. That is, please note down, dear friends, this is very important. Sir Channilal V. Mehta and Sons versus Century Spinning. I repeat, Sir Channilal V. Mehta. Sir Channilal V. Mehta and Sons versus Century Spinning and Manufacturing Company Limited. It is reported in AIR 1962, Supreme Court, page number 1314. I repeat, AIR 1962, Supreme Court 1314. In this case, para number 6 I am referring, dear friends. So the lordships asked themselves the question, what is the proper test for determining? The proper test for determining whether a question of law raised in the case is substantial would, in our opinion, be whether it is of general public importance. See, substantial question of law means if you are raising an issue, whether does it concern the general importance. If it concerns the general importance, public importance, that means it is a substantial question of law. I repeat, dear friends, the proper test for determining whether a question of law raised in the case is substantial would, in our opinion, that is Honorable Supreme Court's opinion, be whether it is of general public importance or whether it directly and substantially affects the rights of the parties, and if so, whether it is either an open question in the sense that it is not finally settled by this court. So if it is concerning the parties and it is not finally settled by the court, affects the rights of the parties, and if so, whether it is either an open question in the sense that is not finally settled by this court or by the Privy Council or by the federal court, or is not free from difficulty or calls for discussion of alternative views. What they are saying is, when you are raising a substantial question of law which is not settled earlier by the Supreme Court, therefore there is a grey area. So that area has to be answered by the Supreme Court in this pertinent case. So we will discuss that later. Yes. We will. Para number 6. Para number 6. So that is what the question of law is. Concerning the general importance, number 1. Number 2 is concerning the parties. Not only that, but also involving that you have to consider that it is not finally settled by any of the courts. And moreover, they are saying if it is already settled principle of law and you want that settled principle to apply to your case, then it does not become a substantial question of law. Therefore, there must be some new law is to be laid on in your case. So, therefore, it becomes a substantial question of law concerning the public importance, or which is not settled earlier, that will be settled now, or it requires an alternative view. For example, the Honorable Supreme Court must have held in a particular view, but now time has come to change the view. Therefore, you will raise a question by saying it requires an alternative view. Time has come to change. So, alternative view is required. Therefore, that is a substantial question of law, dear friends. Please refer this case. Now, moving on to how to draft the question of law on the grounds. This is a practical experience that I would like to give, dear friends, for which I have tried to solve the answer to the questions asked in the 2024. I am referring to the question which was already asked in the AOR examination, Advocate on Record examination 2024, paper 2, drafting. They have asked us to draft either specially petition civil or criminal matter. We can choose between the two. So, what is the facts involved in this case? Therefore, we can draft a petition properly. Let me briefly tell you about the facts of the case, and we will go on to the question of law and grounds. The facts of the case goes like this, dear friends. Father is the owner of the property. Father has let out his property to the tenant. So, father is the landlord, tenant is there. In the month of May, I will give you the exact date later. In the month of May, the tenant vacates the premises. In the month of June, father dies. Now, the dispute between two brothers, father has got two sons. So, they have got an issue. According to the plaintiff, the brother, son, he says that according to him, plaintiff, he is establishing his case. He says that after the death of my father, the property share has come to me, and I am receiving the rent from the tenant. Tenant is paying rent to me. Therefore, he has asserted the possession. On one fine day, my brother, along with other 5 people, they have entered, they have dispossessed me. Therefore, he has filed a suit under section 6 before the district court. Now, written statement has to be filed by the brother, another brother, younger brother. He says, he files it in written statement, there was never partition took place. So, where is the question of share coming to my brother? Number 2, since there is no partition, we are all the joint owners. My brother is also owner. I am also the joint owner. Even my mother, who is the legal heir of the deceased, she is also the joint owner. Therefore, where is the question of possession only to sole possession to my brother? Number 3, he says, tenant, he was already vacated. So, therefore, there was no tenancy of the suit property. It was never let out. Therefore, he is lying before the court. This was his submission. Thereafter, what happened? The district court decreed the suit in favor of the plaintiff. Now, who is aggrieved? The next younger brother is aggrieved. In section 6, there is a specific provision there. You cannot file an appeal or a review also. Therefore, he files a revision petition before the High Court. High Court also says revision jurisdiction means it is very, very limited jurisdiction. The scope of revision is very limited. The court has to see under section 115 of CPC revision that whether the district court has gone beyond the jurisdiction, whether it has exercised the jurisdiction which is not vested with it, or whether it has not exercised the jurisdiction which is vested with it. So, only on the very limited scope alone, the High Court can interfere. Therefore, there is no perversity. Therefore, High Court also did not interfere. So, it is a concurrent finding in favor of the plaintiff, dear friends. Now, he is aggrieved. He comes to you and you are asked to draft specially petition for him. Generally, the tendency is he has lost in two courts. Where is the scope? So, how to draft? Right? Now, we have reached the heart and soul of our lecture. How to frame question of law and how to frame the grounds. Dear friends, first question of law. In my humble opinion, in question of law, we give questions to be determined by the Honorable Supreme Court. But in the grounds, you will give answers to those questions. You will give your own answers in support of the questions that you asked in the question of law. Therefore, for kind consideration of the Honorable Supreme Court. Now, how I have framed and how many question of law, how many grounds that we need to write in the AOR examination. If you look at the lecture series conducted by Supreme Court Registry, the examiners have said 3 question of law is sufficient, 4 or 5 grounds are sufficient. It is not something that you frame question of law, 10 questions of law, then you will end up in answering only one question. So therefore, dear friends, you have to convey to the examiner by saying that you are capable of becoming an AOR. So 2 or 3 questions of law is sufficient, 5 grounds or 4 grounds are sufficient. It depends upon the examiner what they are expecting. So therefore, you need to listen to the lecturer when they are conducting. Now coming to the first question of law that I have framed. Whether the Honorable High Court committed perversity. I always said in our lecture series, the perversity, if SLP is the lock, the key to open that lock is perversity. You try to bring whether your case fits to the perversity or not. What is perversity? Sometimes it is not taught in universities also. Perversity means improper rejection or reception of vital evidence. When there is a vital evidence is there, the learned trial court or the learned high court ignore the vital documents which is supposed to peruse it, or they take into consideration the irrelevant material facts. So what is to be considered, they don't consider. What is not to be considered, they consider. That is what the perversity. That is what in simple terms they say, improper reception or improper rejection of evidence. So this is what the perversity. Now what is the perversity here? Whether the Honorable High Court committed perversity by ignoring the material admission by the plaintiff himself that the tenant vacated on 16th of May 2018. Please note down these dates, friends. 16th of May 2018, whereas his father landlord died only on 12th of June 2018. That is after the death. Therefore, there was no landlord and tenant relationship between the plaintiff and the tenant. Is it right? So in section 6, most important thing is 2 ingredients that you need to fulfill to file suit under section 6, dear friends. First is you need to establish that you were in possession. Prior possession is to be established, number 1. Number 2, you were dispossessed by unlawful means. Your earlier possession and you are dispossessed unlawfully. Then you are entitled for possession even against the owner. Title, who is the owner of the property, that can be decided in a separate suit. That is different. But if you are in possession, you cannot be dispossessed by wrongful means, illegal means, That is what the protection given under section 6. So therefore, what is the perversity? There is an admission by the plaintiff himself who files a suit. He says he asserts his possession. The court will ask, are you in possession? Were you in possession of the suit property? He says, yes, I have received a rent from the tenant. Therefore, he asserts his possession only through the tenant. But whereas in another paragraph, he himself says, he vacated before the death of my father. So therefore, there is no question of landlord-tenant relationship. Plaintiff cannot assert possession through this tenancy relationship, dear friends. Therefore, this point, this material fact was not considered both by the trial court as well as by the high court. Therefore, they have committed perversity. I repeat once again, whether the Honorable High Court committed perversity by ignoring the material admission by the plaintiff himself that the tenant vacated on 16th of May 2018, whereas his father, landlord, died on 12th of June 2018, that is after a month. Therefore, there was no landlord and tenant relationship between the plaintiff and the tenant. So, question of law is framed. Grounds also we have submitted. Now, second question is, again, whether the Honorable High Court committed perversity, which is evident from para 2 of the impugned order. I am referring to the para 2 of the impugned order, High Court order, specifically records that plaintiff asserted possession of the property only through his tenant. When first one is answered, definitely this will also go away. So when specifically records, High Court order records that the plaintiff asserts his possession only through the tenant, then there is no tenancy landlord relationship, then everything goes. Third point is whether the Honorable High Court committed serious error. We are coming to the Supreme Court, dear friends, against the High Court order. That means we are submitting before the Honorable Supreme Court. The Constitutional Court, High Court has not considered our points, my lords. There is injustice to my client. Therefore, please consider. If you have a problem with our own sibling, we go to our father and we'll say, भैया तो हमारा पास झगड़ा कर रहे हैं, please देख लीजिए पापा जी, right? We tell to our father, mother, make a complaint against. Likewise, we tell to the judicial family, High Court, Supreme Court, they are all the constitutional court and constitutes the entire judicial system. We go to the Superior Court, Supreme Court and say, the Honorable High Court has committed error, thereby caused injustice to us. Please rectify. Please provide us justice. Right? That is what we are making the prayer. So for making the prayer, you need to bring out the irregularity, serious error committed by the High Court. So the third point which I have raised here is, which we have urged here is, whether the Honorable High Court committed serious error by not considering that plaintiff has produced pata, rent receipt, water bill, showing that owner was his father. How it is going to be useful to him? That is what defendant also says, right? Father was the owner of the property. Plaintiff who comes to the court, he produces pata, rent receipt, which was issued in the name of his father. So that itself shows that he has no possession. So these material facts, if the court wants to satisfy its conscience, they must have asked, show the water bill, rent receipt that you have received from your tenant, which is not produced. He shows the rent receipt which was received by his father, which was given by his father. It was in the name of his father. Therefore, where is the question of the possession? Now, whether suit is maintainable because of the failure of the plaintiff to prove that he was in his possession of the suit property under section 6 of the Specific Relief Act. So now we are applying the law, dear friends. Whether suit itself maintainable under section 6 where plaintiff has failed to prove his possession. So therefore, dear friends, in my humble opinion, you have to read the facts very carefully. You read 2 times, it will give a different picture. If you read 10 times, it gives a different avatar. If you read 100 times, you will read different. Because every time when you read, you will understand the better understanding of the case. So therefore, facts of the case, senior, when he was arguing, one of the senior advocates in Madras High Court, when he argued before the court, he said, by referring that his senior has taught him, take care of the case will take care of the law. Advocate must take care of the facts and law will take care of the remaining course. So therefore, when we start reading, see the crucial date, death of the father, the tenant vacated the premises. So when that is noticed in the month of May and June, his entire case collapses. So therefore, dear friends, urge the question of law before the Supreme Court, and then you give answers in the grounds. Ultimately, the synopsis, list of dates and events, questions of law, grounds must lead to your destination, that is your prayer, right? So prayer is most important, and this flow is from synopsis. There should be a flow, continuous flow, clarity, coherence, and it must reach that it must create a situation where the honorable court must provide you the justice what you have sought for. So this is how you have to draft, dear friends. Thank you so much for your patience hearing.